Hello, everyone, and welcome to Money Matters with Erin Lowry, a series put on by the Authors Guild Foundation to help authors with financial literacy. Today's topic is estate planning tips for authors. It's very important to prepare your literary estate while you're still here so that your works can continue to be sold and enjoyed when you're gone. Now, as always, webinars put on by the Authors Guild Foundation are free to any writer, so feel free to share the video of this webinar with friends. If you're a member of the Authors Guild, of course, feel free to contact us for legal advice. We can refer you to a state counsel as needed. And please know that your heirs can join the Guild or take over your membership to use our legal services similarly. You can find out more at authorsguild.org. To the audience, thanks for being here and thanks for the excellent questions you submitted in advance. Our panelists are prepared to address those throughout their presentation, and we'll leave time for additional Q&A at the end. I'll just give a general disclaimer that this webinar is offered as informational purposes and it does not constitute legal advice. So please consult your own attorney as needed. Now, let's go ahead and welcome our moderator again, Erin Lowry, the author of the 4-part Broke Millennial series. She's been featured in the New York Times, Wall Street Journal, and CNBC. She's written for the New York Times, USA Today, and is a columnist for Bloomberg Opinion. She publishes a twice-weekly Substack newsletter called Broke Millennial with Erin Lowry. Erin, I'll turn it over to you now. Thank you.
Thanks so much. Hi, everyone. Wonderful to be here, as always. I am not going to take a ton of time in an intro because we have so much to get to. I appreciate all of the pre-submitted questions. We will sprinkle those in throughout. We also will address some of them at the end. And I do want to remind you, feel free to drop questions into the Q&A. I and Johnny will also be monitoring that throughout. Can jump in and ask a few questions here and there, as well as save them for the end. So with that, I am actually just going to turn it over to Edward and Michael so we can get started.
Okay, well, thank you everyone for being here, and thank you to the Authors Guild for putting this on. This is really valuable stuff, and I know Ed and I have had some conversations before this talk, and we're thrilled to be able to give this to you. And so just a little bit about myself. My name is Michael Laron. I am an author. I have written over or published over 80 books at this point, and I write science fiction, fantasy, self-help for writers. And why I'm qualified to talk about this topic is a bit of a unique scenic route. So I have made my career along with writing in insurance. And so I have built a career helping people plan for the future and helping them anticipate problems that can come up in their business, in their personal lives. And estate planning is something that has always been interesting to me. And I also went to law school. I'm not a lawyer, but I went to law school. So my insurance background combined with a limited legal education, combined with being a prolific author who is self-published, who has a lot of content, makes me a bit of a unique voice in the estate planning perspective. And I am interested in this because I want to build a legacy that I can pass down to my family. And so in learning more about estate planning, I'll let everybody know that I did publish a series of books. And the first in that series is called the Author Estate Handbook. And I'm happy to drop a link in the chat and mention that to anyone who's interested. And it goes through a lot of things that self-published authors in particular should consider, as well as the boots on the ground things that can help you have a really productive conversation with your attorney. So if you go to Ed, it helps you have a really good, high-powered conversation with him or your attorney so that they can help you and figure out what your needs are and help you a little bit better. So that's my background in a nutshell. And the first thing I just wanted to talk about and something I want everyone to think about is that, we're going to cover some pretty good stuff in this talk. We're gonna be specific on some things, but the important things like wills, trusts, talking to an estate planning attorney in the first place, that's something that we highly advocate for all of you to do if you have not done it already, because that is a critical step. There's a lot. Estate planning is kind of like herding cats that don't want to be herded in many respects, but having that conversation sooner than later is really important. And you're never too young to plan your estate, and you're never too old to plan your estate. And the most important thing that you should also think about is who you want to plan your estate, or who you want to take over when you're gone. So whether it be a spouse, a family member, child, grandchild, it's really important to pick that right person and make sure that they know what they're getting themselves into. Because I think a lot of you can relate to what I'm about to say, is that in that you spend an inordinate amount of time in a room by yourself making stuff up, and your family has no idea what you do every day, right? And if you die and they don't know, then it becomes very difficult and it can become a burden. And so I think the focus of this talk today is how can we make it so that it is less of a burden for your heirs and that you can take care of them. So I'll pass it over to Ed.
Okay, thanks, Michael. So yeah, I'm really excited about co-presenting with Michael today. I like the way we've broken this down in terms of what each of us is going to talk about. I'll be discussing ways that you can set up your literary estate plan from a legal perspective, and Michael will discuss how you can organize your literary property to ensure that your estate plan with respect to that property can be implemented as seamlessly as possible after your death. To provide some of my own background, I'm a trust and estates practitioner in private practice, but for many years before that, I worked as an attorney in the book publishing industry. I handled copyright and other legal matters at the Authors Guild. That's where I got my start. And then I went to the Association of American Publishers, followed by McGraw-Hill. So nowadays, on a day-to-day basis, I work with clients on estate planning and administration matters generally. And fairly frequently, I'm approached by either an author or the surviving family members of a deceased author seeking assistance preparing an estate plan specifically with regard to the author's literary property. I'm going to be giving some examples of New York State law and practice because I'm licensed to practice law in New York. But if you live in a US state other than New York, or even if you live outside of the United States, everything I say will still be relevant. Those examples that I give are only intended as examples, and you can take the strategies that I bring up, discuss them with your local trust and estates counsel, and see how they might be applied under the laws of your respective jurisdiction. Because trusts and estates in the US, for instance, is governed by the state statutes wherever the decedent is domiciled at the time of their death. Also, there is an example I'm going to give involving a spouse and children, but for anybody who happens not to be married or who doesn't have children, the example will still be completely relevant for you. You can just, in your own mind, replace the spouse or the children with an extended family member, a friend, or anyone else for whom you may want to make provisions in your literary estate plan. And finally, I have read Michael's book, The Author Estate Handbook. So here and there, I'll be making some references to the content of Michael's book. So now, Michael, I think you're going to discuss the ranges of pieces of property that could comprise an author's literary estate.
Yes, Ed, thank you. So we want you to think about your estate as not just your books. So I'll take a few minutes and talk about other things that can be included in your estate. So it's easy to think about just your books. And what I'm also going to say is that what I'm talking about will apply to self-published authors as well as traditionally published authors. You just have to season it a little bit to your situation. So when we think about our estate, we think about our books and the copyrights associated with those books. And that is probably that's the crown jewel of your estate. But there are other elements of your estate that you should also think about. For example, what about the book production files? So you have an edited manuscript. Your manuscript went through multiple revisions. It had to be formatted either by your publisher or through you if you're a self-published author. That's probably in Microsoft Word format. If you're a self-published author, you're going to have an EPUB, a MOBI, a PDF version of that book out there somewhere. And so where will your heirs find those things? How will they find those things if they want to upload the book to a new retailer, or if they want to make an edit to the book, or if there's a typo, or if they want to make a new edition? They need to know where the raw book files are so that they can administer those changes. There are also things like short works. So if you've written short stories, if you have written poetry, blog articles, these things are also part of your estate. You own the copyrights to those things, and you can exploit those, and so can your heirs after your death. The physical book inventory that you might have for authors' copies, or marketing materials that you might take to a con or a conference, these are also things that are part of your estate. And there's another element that's really important, and that is your website. So whether you're a traditionally published author or a self-published author, you probably have a website. And that website is your calling card. That's where people are going to go when they want to know more about your books and about you. And you want to make sure that your website also remains operational after your death. And you want to be thinking about how to teach your heirs how to keep the website operational, and also how to make updates to it. So if your estate comes out with a new edition of one of your books, do they know how to upload that to your website? Do they know where you pay for your domain? There's a domain name associated with your website. You've got to pay that every year in perpetuity. If you don't pay that, then it can lapse and someone else could buy it. That is a disaster scenario. You do not want that to happen, or that to fall by the wayside. And then there's things that just real quick, like social media platforms, your Facebook page, your Twitter page, your YouTube channel, if you have a YouTube channel. What do you want your heirs to do with those things? What can they do with those things? And I know a lot of people don't like to hear the answer, read the terms of service. Sometimes that's anathema if you're not an attorney, but you really do want to read the terms of service for the services that you use to figure out how you can pass those down to your heirs, and what things they need to think about. And finally, particularly for self-published authors, your mailing list. So this is a list of buyers. That's really the way to think about it. It's a list of your customers, readers who have bought your books and signed up for your list so that they can get future updates for your books. Super important. So these are things that you want to be thinking about in your estate in addition to your copyrights. And I'll pass it over to Ed to talk about differentiating your literary property from your non-literary property.
Okay, so Michael, one of the other topics you address in your book is how an author lumping their literary property in with everything else that they own when creating their estate plan can result in a lack of clarity and practical problems in implementation after their death. And a hypothetical that I like to use to illustrate this point when I give these talks is that I'm a prolific author, I'm married, and I have 3 adult children, all of whom are sons. And in my will, I make no specific reference to my literary property, all of the types of property that Michael just described. Instead, I provide that my residuary estate, all of the property passing under my will be given at my death to my wife if she survives me, or if she predeceases me, will be given to my 3 sons in equal shares. And as it turns out in the hypo, my wife dies before me, I'm survived by my 3 sons, and my executor, the fiduciary under my will, in an effort to implement my estate plan as articulated in my will, assigns all of my copyrights to my literary works to my 3 sons to own as tenants in common, each in a 1/3 share. Distributing my copyrights in this way, however, could lead to a whole host of questions after my death. First, who will take the lead in dealing with retailers, distributors, online services, and others? Who will manage my website and social media pages? How is a decision reached as to whether to accept an offer for publication of an out-of-print book of mine by a new publisher? If there's an opportunity for an introduction to be added to the new edition, who vets the selection of the person to write the introduction? Who will review royalty statements and for given works, chase down unpaid royalties. And then on the flip side of that, if there are any monies owed to somebody else, such as an illustrator or a co-author with whom I collaborated during my lifetime, who makes sure that those payments get made? Who will decide whether to have published certain unpublished works of mine? With respect to any manuscripts that I may not have finished, should an additional author be brought in to complete those manuscripts so they can be published? And with regard to new publications, will a traditional publisher be sought, or will self-publishing be pursued? And if the latter, on what platform or platforms? And who decides on the cover art? And so you're getting the picture, I think, that perhaps my estate plan should have achieved something different than my three sons together owning each copyright, together having to make decisions of the type that I just described, and together having to take the steps necessary to administer my literary estate. So there are a few potential alternative approaches. One that many authors who contact me express interest in is setting up a literary trust. And this involves transferring all of the author's literary property into a trust so that after the author's lifetime, one trustee at a time, ideally in my mind, administers that property for the financial benefit of potentially multiple beneficiaries. So the beneficiaries in my hypo could be my three sons. Another possibility is to give all of the literary property to an individual or maybe an organization like the Authors Guild, but a beneficiary that will be the sole owner of all of the literary property, and then will keep all of the revenue from the licensing, sale, distribution, and other uses of the works. A third possibility, although I have not had occasion to pursue it with any of my clients, might be to give different copyrights to different beneficiaries. So in my hypothetical, copyrights to books A, B, and C to my oldest son, copyrights to certain other works to my middle son, and then the copyrights to the balance of the works to my third son. That wouldn't resolve, however, questions such as who is going to manage the author's website and social media pages, at least insofar as the pages aren't dedicated to just one book, and the site isn't just a website for one book. Moreover, and this goes back to what Michael said at the top of the webinar, it can be very challenging to identify one person, let alone multiple beneficiaries, who will be willing to step up to the plate and put in the time and effort necessary to effectively administer the literary estate. And Michael discusses in his book how much responsibility is involved. It's really a great deal of responsibility. So the bottom line is that each author's situation is going to be different. And when preparing your overall estate plan, both with regard to your non-literary property and your literary property, you need to make specific provisions with respect to both the disposition and the administration of the literary estate. And before I talk about those subjects in more detail, Michael is going to discuss the topic of digital assets.
Yes.
Just real quickly, before we get into digital assets, there have been a few questions, one that came in pre-submitted, one that just came in, around what happens if right now your book is not selling a significant number of copies, maybe your royalties are fairly modest, but you're then maybe making decisions about who would be handling the estate with that information. But what happens if maybe you gain a certain level of notoriety after your death and your estate becomes a little bit more complicated? What are some of the thoughts about, again, thinking that through, and does it change how you designate an executor of your estate in that particular kind of case?
Yeah, I can take that one, Ed. I would say that that is something that you should discuss with whoever you choose and make sure that they're aware of that potential possibility. Because yes, I mean, how many authors have we read who were relatively unknown during their lifetimes, but their books took on new work, new lives after they died. So that is very much a possibility and something that you should consider. And yes, they should be prepared that a book could explode, and that's a wonderful thing for them, but they just have to understand, okay, well, what does that mean from a estate management perspective? What do they have to do every day to help with that, whether it's running ads, taking advantage of whatever opportunities might come up. So I think the training of your heir is really, really important and something that shouldn't be overlooked. You have to train them to teach them how to manage the estate. It's not something they're just going to be able to figure out. So train them to the extent while you're here, and that'll set them up for success in the future. Okay, well, let's start talking about digital assets. So this is really important. So if I said the following thing to you, I don't think anyone on the call would be surprised to hear me say it, and that is that passwords are important. Okay, we can all go home now. Everybody knows that. Passwords are important. But there's another thing that's important as well. Okay, so before we talk about that other thing that's important, I also want to make sure that people think about where you store your passwords. So I know people that are pen and paper people, and that's completely fine. Just make sure that you store it in a place that your password's in a place that's not going to burn or that's not going to flood, and that your heirs know where it is. It's really important. Now, if you are a digital person, I recommend a password manager. And a password manager is an app like 1Password, LastPass, Bitwarden, Dashlane. There's dozens of them out there. And it's basically like a digital wallet that stores all of your passwords. All right. And the important thing about password managers, and this is really critical, is that one, it just makes it more convenient for you to administer your passwords because it saves them. And you can load them into any browser, and you can get your passwords with the click of a button without ever having to remember a password. And they also allow you to create very long and difficult passwords that are a lot harder to hack. But the other thing that's really important for estate planning that makes them a great estate planning tool is that they have an emergency access feature. So let's say, for example, that you were to pass away tomorrow. You could designate an individual, so say your executor, to have emergency access to your password manager. They follow a designated link, and upon going to that link, you can designate a waiting period, 24, 48 hours or none, and then they can immediately get into your account and get all of your passwords. This is, I think, one of the best things that you can do because one, you don't have to write all your passwords down. You don't have to remember them. All you have to remember to do is give them instructions on how to get that emergency access. So that's the thing I want to say about passwords. Also, some people may lock their computers with passcodes and passwords. You may lock your phone with passwords and passcodes. If your heirs can't get into your devices, game over. So all the things we talked about with your books, your website, your social media, they can't get into any of that if they can't access your computer. So that's a really important thing to also think about. Make sure you write those down as well. So a really great way to do this is to take an index card and write your passcode devices on the index card and make sure your heirs know where that is. And that will solve this problem, making sure that they can get into your devices and then making sure that they can get into your accounts. Because I read that the average person has somewhere around 300 accounts. And as authors, we probably have way more than that, especially if you're a self-published author. There's lots of dashboards and retailer accounts that you'll have to log into. So just keep that in mind. Now, the second thing I want to talk about, and this is something that a lot of people aren't aware of, and that is I want people to think about two-factor authentication. So two-factor authentication is when you log into an account, you put in your username and your password, and then usually how it works is you get a one-time code sent to your phone usually, or your email address. You have to take that code, put it into your account in order to get access. Now, if you can't get that passcode, you cannot get into your accounts, even if you have a username and password. So I want that to sink in for a second. Let's imagine that you have passed away and your heirs, not understanding two-factor authentication, they disconnect your phone line. And so now they go to your accounts and they put in your username and your password, and then they have to get a passcode, but your phone number is disconnected. They can't get your passcode. So even though they have your passwords, they're forever locked out of your accounts. And on some sites, from big companies, I'm not going to name names, but some website companies, you're not even going to be able to get someone on the phone to help you. And do you really want to hire an attorney to help you with that and go through all of the legal trouble and heartache when you could just solve this problem right now? All right. So what I would encourage people to do is make sure your heirs understand two-factor authentication. Make sure that they understand not to disconnect your phone line until they have changed over the phone number in all of the accounts where you do business. All right. And in my book, I also I have an entire section on this, and we go over exactly how you can avoid this problem. There are some other alternatives that you can train them to do that will make your life a lot easier. But if you don't solve this problem, all the stuff that Ed and I are going to talk about, all the stuff that we've talked about, all the estate planning advice, it's not really going to help your heirs that much because they won't be able to manage your estate. And with that, I will turn it back over to Ed to talk about some more estate planning specifics.
Okay, thanks. So when I'm preparing for provisions for inclusion in a will, a trust, or otherwise as part of an author's literary estate plan, I work with the author to define what's in their literary estate and include specific provisions with regard to that property. Now, Michael has just talked about ways to organize your property and provide the necessary tools and transparency, which are critical for your successor in interest after your lifetime to gain access to your digital assets. And then on the legal side, I include detailed provisions to avoid legal impediments to accessing the digital assets. So in the will or the trust, you want to give your fiduciary, which is your executor or your trustee, the express power to collect, access, and administer your digital assets. And this includes, as Michael mentioned, your computerized devices, everything from your PC to your phone, all of the content and data stored on the devices, your internet-based accounts and data, your domain name registrations and administration, and the content of your emails, which can be critical for gaining access to your online accounts. Without these express written authorizations, online service providers that power the digital assets, like the online service that provides the hosting space for your author website, they may not be willing to grant access because they don't want to run afoul of any federal or state laws governing online privacy and unauthorized access to computerized data. So what will happen is, ideally, the executor will be able to provide the specific provisions in your estate planning document in which you, the author, authorize your fiduciary to gain access to your digital assets. And looking at these provisions, hopefully the online service provider will provide the access. Some online services, however, require that a court order be issued compelling access. And in those instances, the court looks at the provisions of the estate planning document to determine whether to grant the order, and if so, the scope of access to compel. Furthermore, the estate planning document that I prepare will expressly give the digital assets included in the author's literary estate to the beneficiary who is to receive the literary estate. So under an author's will, again, that might be an individual who is a beneficiary to take the property outright, or it could be a trustee of a literary trust created under the will. Michael also talked earlier about other pieces of property that can be part of an author's literary estate. And so these also will expressly be part of what is given under the estate plan. various classifications of written works other than books that the author may have created during life, maybe articles, blog posts, works of poetry, screenplays. And with regard to the books and any other writings, all copyrights and any other intellectual property rights to the works, all contractual rights associated with the works, any derivative works based on the books that may have been created during the author's lifetime, like audiobooks, maybe merchandising like apparel and games, stage adaptations, graphic novels. And what's given as part of the literary estate also includes the rights to create new derivative works after the author's lifetime. The literary estate can also include all documents and records pertaining to the author's literary career. These can be physical items as well as items stored digitally, such as manuscripts, contracts, correspondence. Michael mentioned marketing materials or plans and other such materials. And sometimes an author will want to give particular physical items to an archive, maybe at the college or university that the author attended, or to a community organization in the geographic area where the author lives. Importantly, when this is done, the deed of gift governing the donation to the archive and the estate planning documents as well should expressly state that the only things being donated are the physical items and not the underlying copyright interests. So for example, if an original manuscript of one of your books is given to an archive, you want to make it clear that the archive is not also being given the rights to publish a paperback edition using the manuscript. Finally, if you have established a business entity in association with your career as an author, that's also part of your literary estate. So provisions need to be made one way or another for its disposition at the time of your death. Many authors set up single member LLCs. So one option there would be to execute an operating agreement that provides when the author dies, a particular beneficiary or a particular individual will become the sole member and manager of the LLC. And then if the author has not made such provisions in an operating agreement, then the LLC interest might pass under the author's will and be part of the literary estate passing under the will. Okay, and Michael, your next topic is how to document your literary estate.
Yes, but Erin, you can go ahead.
Yes, before we get to documenting, and I just wanted to clarify with the university archive, we did have a few questions about donating works. And I just want to clarify that if your university is archiving your work, they're just filing it away. They are not the administrator of your work, or can you also name them the administrator of your work?
So I have not been involved in situations where the university offered to do that. It might be something more like the university houses an archive for any alumnus who wants certain aspects of their life to be reflected in an archive at the institution. And that would involve materials being there on the premises and being made available at least to students and maybe certain other researchers, and could include the author's writings, could include if the author was involved in some public policy initiative, maybe materials relating to that. I mean, it could cover a whole host of things, but no, at least in my experience, I've not been involved in arranging for an institution of higher education, for example, arranging for them to administer the literary estate. Well, not to say it can't be done, but I haven't observed that.
Okay, so Ed just described Okay, thank you. So Ed just described in great detail how to think about being specific when you are planning your estate. So specificity is really important. You know, he talked about you don't want to accidentally give your copyrights to an archive or to a university when you intend to just give them your book, right? So that is really critical, and it's critical to really have this conversation with your attorney to make sure that they can advocate for you and really help you with your planning. And one of the things that you can really help your attorney with, your attorney's not going to know your situation. They're not going to know the nuances of your situation. They're going to ask you questions, but you have to tell them what you need. And you also have to tell your heirs what you need and what your wishes are. So when you're having a conversation with your attorney, it's really important that you are clear and specific with them about what it is that you want to accomplish so that they can do it for you. And it's also clear to be specific with your heirs about what you want so that they, when they're having a conversation with an attorney, that they can help you as well. So the legal side of things and structuring your literary trust and making sure that you make the right designations in your will and all of that is vitally important. But there are other elements as well that your attorney may not be able to help you with. And that is the everyday documentation of your estate. So, for example, where do you store your books? Where are they at? Are they in the cloud? Or are they in a special folder on your computer? Where do you keep all of your business documents, like your tax documents, or as Ed mentioned, your operating agreement for your single member LLC? Where are those things? Do you have a bank safety deposit box where you keep vital and important materials? These are all things that your heirs are going to need to know. And so I think it's also important to be thinking about how you can document your trail in a Word document, in an Excel document. What are all the things that you own? What is all the property that the estate owns? I think is really important to know. You don't want your heirs to not know about a short story that you had published or a book that was a work in progress that you were working on before you passed away. They should know where all of that stuff is. They should know what all the metadata is. So for example, what is the price of that book across all of your different formats, ebook, paperback? What is the sales copy? So what is the book description? Where do they find that? I mean, just document your trail. Just think about it like if I were an heir and I were coming to this estate, what are the things that I would want to know? And as I said before, I can't say it enough, use this as a training opportunity. We have to train our heirs to do what we want to, what we want to do and what they want to do, because they benefit from this as much as we do. And so understanding that and managing that expectation, I think is really important. And it also shows some empathy for what we're about to put them through, right? As Ed alluded to, this is a lot. It's a lot. On the legal side, it's a lot on the day-to-day administration. And so writing a letter to your heirs, describing how you do things is also critical. Recording videos, hopping on a quick screen share and show them how to format a book, for example, or show them how to upload a book to Amazon, or record a video and show them where all of your traditional publishing contracts are. These are all things that you can do, and you can do relatively easily and quickly to help document everything that needs to be done. And I think your heirs will thank you for that because one, you're going to get on the same page with them. Two, they're going to understand what they're getting into. And some may say, oh, I'm crying uncle, I can't do this, right? And it's better to have that conversation while you're alive so you can find the right person. And three, it just makes the administration of the estate so much easier and less of a burden, because it is a lot of work. And so I just want people to think about how to start documenting your decisions, because we do a good job of making those decisions for ourselves, but we don't always do a good job of communicating that with our heirs. And I think our heirs should be the predominant concern. And with that, I'll turn it back over to Erin. I think you have a question.
I do, Michael. Those were such great points about needing to communicate. And perhaps it's for people who do an excellent job of communicating, their heirs get a little spooked and decide, I'm going to cry uncle now. I don't want to take on this responsibility. So we've had some questions come in about how do you pick somebody to be your literary executor, but also if your heirs really have no interest in performing that role, what are your options?
Yeah, it's tough. It is tough. This is one of the biggest gaps. I mean, Ed and I talked about this when we were preparing for this webinar, that there are going to be some authors out there who may not have someone. And unfortunately, we talked about universities or archives, but I don't have a good definitive answer other than, do you have author friends that might be willing to step in and take over things for you? That could be another potential option. Ed, do you have any?
Yeah. So yeah, it's the biggest question. I think it's the biggest challenge. And I would say a few things. First off, Michael mentioned author colleagues, friends. Sometimes people will name their literary agent. If, of course, the agent has to be willing to serve, and the agent would need to be sufficiently compensated over time to justify the time they would have to spend. I know that the Authors Guild sometimes accepts bequests of an author's literary estate. My understanding of that is if the projected annual royalties from the works in the literary estate would enable the Guild to cover its costs to manage the property. Another thing I would say is, if there is a friend or family member who maybe doesn't have a lot of experience and lacks confidence with respect to their ability to perform all of these responsibilities. One, Michael talked about giving the person the tools they need, training them, all of that stuff is invaluable. And then again, in terms of what I include in the documents, when I create these literary trusts, the trustee is expressly empowered to use trust property to hire professionals to assist with a publicist. They can pay literary agents. They can retain the services of an attorney. So gradually, to the degree that they don't already, they don't hit the ground running in terms of knowing everything that they need to do, they gradually, I think, develop expertise, and they can draw on the expertise of others to assist them.
Yeah, absolutely. And that's another thing too, is that your heirs don't necessarily have to do all the work. They can hire somebody if your estate is making, enough money for them to do that. And just don't forget too that, copyrights, you enjoy the benefit of your copyrights for your life plus 70 years, at least here in the United States, similar in other countries around the world. And I think you should communicate with your heirs what they can earn. And, from a financial perspective, I mean, there's money on the table that they can earn. And so I think if you can be clear with them about that, that might help them get more comfortable with it as well. All right, Ed, did you want to talk about literary trusts?
Well, yeah, I know we're short on time, and I don't want to use up too much of the Q&A time, so I'll just say this. The way that these trusts get set up, there are two ways. One is to provide in your will for the creation of the trust after your lifetime. That's called a testamentary trust. The other way is to set up a revocable living trust. Revocable living trusts are popular for people who, for whatever reason, want to avoid probate, at least with respect to certain property. Probate is the process of getting a will admitted to probate and getting the executor appointed by a court. But you can have more than one revocable living trust. So you could, if you want to have a revocable living trust that you fund with your house and your investment account and so forth, you can do that. And you could have a separate revocable trust for your literary property. And it's not as if it's the point of no return if you transfer your literary property into a revocable living trust. So long as you're alive and you understand the nature of what you're doing, you're not ill or something like that, you have total control over the property in the trust. You can always take property out and change the provisions of the trust document. Oftentimes, the author would be the sole beneficiary and the sole trustee of the trust during life. And then upon the author's death, either a co-trustee who continues to serve or a successor trustee named in the trust document will continue on and administer the property in the trust and periodically pay out net revenues from royalties and so forth to the beneficiaries. And Michael made the point that most copyrights nowadays last for the life of the author plus another 70 years. So I always include provisions to ensure longevity in terms of beneficiaries and classifications of beneficiaries, like if one remainder beneficiary dies, maybe the trust instrument can make their children and other descendants, known as their issue, the beneficiaries of subshares of that person's share. And then we also include provisions to ensure that there is always a trustee or a mechanism for appointing a successor trustee to act. So that's a very short capsule summary, but I'd be happy to answer any questions about that during the Q&A or in the future.
Well, thank you both so much. I know this is a ton of information to go through, and an hour is just not enough to dig into all of it, but we're going to try to answer a few more questions here in the time that remains. So first, actually more of a technical language side, could you define the differences between a trustee, an executor, and an heir?
Oh, sure. Okay. All right. I'll start with an executor. That's a person who, so when a person makes a will, that person's called the testator. The testator nominates an executor in the will, and usually at least one successor in case that first person can't serve. Then, at least in New York, when the testator dies, the will is offered for probate. A petition is filed in the surrogate's court, which is the probate court in the county where the testator was domiciled at death. The court is asked in the probate petition to formally and legally appoint the executor nominated in the will. The executor collects all of the property that's passing under the will and uses estate property to pay estate debts, any taxes due, administrative expenses of the estate administration expenses. Ultimately, the executor is normally entitled to take commissions, and then the balance of the property is distributed out to the beneficiaries under the will. A trustee is a different type of fiduciary. They're a fiduciary who manages the property in the trust, and they have a fiduciary responsibility to the beneficiaries of the trust, who are the people who in the literary trust would get the periodic distributions of net royalties and so forth. And an heir, so an heir is sometimes, the term is sometimes used sort of generally to refer to surviving family members and beneficiaries and so forth. But from a technical standpoint in New York, we interchangeably use the terms distributee and heir at law. And what that means under the statute is people who, if the decedents didn't make a will, any property that's not otherwise disposed of, such as through a beneficiary designation on a bank account or something of that nature, will pass to the distributees through an administration proceeding. That's called, it's dying intestate, not leaving a will. And so the distributees are defined by statute. So if you have a surviving spouse and children, then they're the distributees. And then after that, you go up to both spouse and issue, then up to parents, then down to siblings. There's this whole hierarchy of people who may be your heirs at law if you die without a will in New York.
Thank you for that. Estate planning attorneys. There are a lot of questions about how to find one, particularly somebody who specializes in literary questions. I'll just put it that way. One particular viewer had a situation where she and her husband had hired an estate planning attorney, and then they kind of got to the fact that she has all these literary works and he seemed completely clueless, didn't know how to move forward and proceed. So how does a person find someone who is the appropriate estate planning attorney for these particular situations?
Well, maybe I'll make a quick point and then I'll see if Michael wants to add to it. So I'm licensed to practice in New York State, but oftentimes I'll work as a consultant to an author in another state where they have their own local trust and estates council. And I'll prepare proposed provisions for review by both the author and their trust and estates attorney. And the attorney will review the provisions to ensure their conformance with state law. And that has worked rather well. Michael, I don't know if there's anything you want to add.
Yeah, that's a great, that's exactly what I was going to say. And I live in Iowa, and it's very hard to find somebody that specializes on the literary side here. So that's what I had to do. Essentially, I had to talk to two different attorneys. I had a local estate attorney, and then I had another attorney that was in Chicago that was able to help me with the language. So that is one way to do it. But the importance of finding an estate attorney that is willing to do that, it cannot be understated. With my first will, I told my attorney I had books, and I think that was a smart thing for me to do, but they did not do a good job with the actual administration of the will. So finding two people is probably the right way to do it. It's a rare unicorn to find an attorney that can do it all, especially in your state, especially depending on where you live. New York might be easier, but Iowa, not so much.
That actually comes to a question that came in a few minutes ago about, do you have to hire somebody in your state? Is that a requirement? And then I'm going to tag team my own question to follow up. If you create an estate plan, let's say in New York, and then you move to Iowa, do you have to redo the whole thing because you moved?
Yeah, so well, in answer to the first part, yes, it's because your estate plan will be, the implementation of your estate plan will be governed by the laws of the state where you have your place of permanent residence at the time of your death. So you need an attorney, well, wherever they're located, they need to be licensed to practice in that particular state. And if you do change your domicile to a new state, then it's highly recommended that you meet with an attorney in that state to review your estate plan and potentially update it in light of the laws of that state.
Excellent. So splitting between different people receiving, for instance, is it possible to leave your copyrights to one heir and then your royalties to another? Or is that just really going to be a difficult thing for folks to handle in your death?
Well, so yeah, I'm not sure that would be workable, but that's kind of the idea of the trust, is that there's somebody who would be well suited to serving as trustee. Like in the my three sons example, maybe my oldest son, Eddie, maybe it turns out that when he's all grown up, he has a real interest in books and is passionate about all of the books that I've written. And of course, this is a hypothetical. I'm not a prolific author like Michael. But so Eddie would be a good candidate to be a trustee. But the other two have no interest. So he could manage, he would be in possession of all of the copyrights in his capacity as literary trustee, but royalties would flow to whomever I name as beneficiaries, which might be the three of them.
Now, Michael, you said something important a little earlier. You said my first will, which would imply that you have updated since then. And so my question is, at the very beginning, you mentioned you're never too old to start. It's never too, I think, early to start either. But how often should you be updating? So what are inciting incidents, I guess, to
yeah, it's a great question. At a minimum, you should be looking at it every few years. Major life changes, I think, are important. So if you have a child, people in your family pass away who were designated on the will, I think all of that is probably a time you should talk to your attorney. And then also just every few years, it's not a bad thing to talk to your attorney just to see, have there been any changes that I need to know about? I think just personally, that would be what I would do after major life events like moving, deaths, births, divorces, marriages, those sorts of things. And then, periodically, just to make sure there's nothing you need to be thinking about. Ed, do you have any thoughts on that?
Yeah, I completely agree. And yeah, you mentioned people eventually passing away. So maybe there are people who are named as fiduciaries, but a lot of time has passed, and some of those people may have died or moved away. And meanwhile, people who might have been very young when you created your estate plan in the first instance have grown up, and maybe they're good candidates to be named as fiduciaries. Also, when you acquire some substantial new piece of property, a home or a new investment account, it's advisable to talk to your estate planning attorney to see what you should do. Like when you create a new investment account, you'll have the ability to name a designated beneficiary, and that would be outside of probate. Upon your death, by way of a contract between you and the financial institution, that asset would pass to the beneficiary. But in the context of your overall estate plan, maybe there are some instances where it would be better for a financial account other than a tax-deferred retirement account. Those are best. It's best to designate beneficiaries for those for certain tax reasons. But a standard investment account, maybe it's best if your estate is the beneficiary, so that your executor will have access to the necessary liquidity to pay carrying charges on a house that might pass under the will. So the real estate taxes, homeowners insurance, general upkeep. But it's very specific to each person's property and their personal family tree and personal situation. So it's best to err on the side of contacting your estate planning counsel when there's a major life event of the type Michael just described, or you acquire new property of some size.
And I'll just say one final thing. The world changes. If you had your will done in year 2000, completely different world now. And so it would behoove you to get that updated as well. So if you've got something out there that's old, not a bad idea to look at it again.
Well, thank you both so much for your time. For everyone who has tuned in, thank you. And thank you for submitting such wonderful questions. As a reminder, we also do have a webinar from, I believe it was 2021, an estate planning webinar. So perhaps if your questions weren't answered in this round, they might have been in the prior one. Certainly recommend checking that out. Ed and Michael, we thank you so much for your time. And for those of you tuning in, we will also be sending a follow-up email with more information about Ed and Michael. But I am going to plug your book one more time, Michael. It's the Author Estate Handbook, and at authorlevelup.com is where you can find it as well.
Thanks, everyone. That's all for today. If you have any questions for the Authors Guild, feel free to reach us at staff, STAFF, at authorsguild.org. Thank you.